Brian Schutte, and one of my practice areas here at the firm is estate planning. So we thought it might be beneficial to make a short video for you to give you some introductory information, and the idea is that you might watch this video before you come in for your initial estate planning consultation. Estate planning sounds a little more fancy and complicated than it really is, at least the way that we do it. It's essentially making decisions in three key areas. First, what's going to happen to your assets when you die? Who's going to make business decisions for you if you lose the capacity to do that for yourself? And who's going to make medical decisions for you if you lose capacity to do that? These are all things that we'll talk about in our first office conference, and I want to give you some things to think about in advance of that. Let me address each of those briefly. The question of what will happen to your assets, this is what most people think about when they think of estate planning. For our purposes, you need to come here knowing, of course, who your family members are and how you want to distribute your assets to family members and also to non-family members, or sometimes to a local charity like the university or your church or some nonprofit ministry in the community. You also need to decide what specific items you might want to give to specific people. For example, if grandpa's shotgun, that's an heirloom, or grandma's ring, or some silver, or dishes. There are all kinds of things that have not necessarily large monetary value, but they're very important to a person, and they want to make sure that it's passed down in the family as a part of that the legacy of the parents or grandparents or what have you. We also can decide about the specific way that assets pass. For example, if there's a family farm and maybe there's another family member that helps to operate that farm, you may want to give that family member what's called a life estate. So they have the right to use that farm for as long as they're living, or maybe you would condition it on their continuing to farm, and as soon as they stop doing that, then their interest would go away, and the remaining interest, called a remainder interest, would then pass to the heirs of the person making the will. What is most typical in deciding what to do with assets is for each spouse, if you're married, to leave everything to the other, and then to distribute what's left to children or grandchildren in equal shares. Obviously, you're limited only by your imagination. You can change those things and do whatever is appropriate for your circumstances, and part of our job is to help you make those decisions and then write it up in a way that is clear and to assure that your intentions are carried out. The second thing that will help you work through is the decision of who will make your business type decisions in the event that you lose the capacity to do that. Nowadays, people are living longer because of medical technology. It makes it a little more likely that a person will live longer than they have mental capacity to make decisions, and just sort of a deteriorating intellectual ability. It's a sad fact of life, and it's something that's important to address in the planning process. And we typically do this through powers of attorney, a document everybody's familiar with. You appoint a person, and you can specify what authority they have in that document, and they can step in and make decisions like banking decisions, or selling real estate, or selling stocks and bonds, or dealing with your cash, or just generally dealing with any business item that you would deal with yourself if you were able. And you do that using a power of attorney. We typically recommend that you have more than one power of attorney, because most of the time people will appoint a spouse to serve in that role, and it's not beyond the realm of possibility that you and your spouse could end up in an accident where you could both become incapacitated. So if the only person that you've appointed is the spouse, you end up falling through the cracks, and the only option at that point is for you to get a court-appointed conservator or guardian, which involves a jury trial, and it's a months-long process, and it's something that's best to avoid if it can be avoided. The second person, though, that you choose, you need to choose very carefully, because they have a lot of power under this document. So we help you kind of think through those issues and choose the best person to fulfill that role. The third thing that we talk about with you is who will make medical decisions. This one's obviously a very important one. And there are a couple of different approaches. If you've been to the doctor recently, undoubtedly you've been asked if you have a living will. and a lot of people use those, and they do have their benefits. It's always been my preference, though, to use a different kind of approach. It's what's called a designation of healthcare surrogate, which is really just a fancy term for something like a medical power of attorney. In that document, you are empowering another person to make decisions on your behalf when you lose the ability to do that for yourself. And the benefit of the healthcare surrogate is that that person is going to be making decisions in real time at the time that the need arises. They'll be doing that in consultation with the doctors, and so it's going to be a decision that's much more closely calibrated, if you will, to your actual circumstances. Whereas with a living will, that's you and a lawyer sitting down one day and writing out some potential outcomes for various scenarios. And as helpful as that is, it's not nearly as helpful as empowering a trusted person to make decisions in real time in consultation with the medical professionals who are attending to you. When you come for your first consultation, you should bring all of your existing estate planning documents. If you can't locate them, it's okay, because what we will do for you will replace all of those. But it's always helpful to have those so we can get a feel for the decisions that you've made in the past and try to plan in a way that's consistent with that. So bring any prior wills or existing wills, bring any powers of attorney that you have, any living wills, any designation of healthcare surrogate or medical power of attorney, basically all of those documents. You've probably got them in a single place. Just grab those before you come to the office, and we'll look those over as we go through the process. A final thought on the estate planning process. It's not a particularly burdensome process to go through. It doesn't necessarily take a lot of time, and it's not particularly expensive regarding the legal fees, but you do get a really big payoff at the end of it, and that is peace of mind. You have the peace of mind of knowing that you have dealt with your affairs in an orderly way, and probably most importantly, that you've assured that things will be as easy for your family as they can be as they wind up your affairs after you're gone, or help you deal with issues toward the end of your life. We appreciate the opportunity to serve people with estate planning needs and look forward to working with you.